Are you in the position where, for whatever reason, you just really need to fire your attorney, but you have no idea how to do that? You want to know, what steps should I take to fire my attorney? Well, in this video, I'm going to go through 3 different ways that you can fire your attorney, and bonus tip as to something you need to know if you plan to represent yourself. Hi, I'm Naomi from Gonzalez Law, Legal Insights from California Attorneys. Today we're talking about how can you fire your attorney. For whatever reason, sometimes people feel that they do need to go ahead and fire their attorney. There could be a lack of action, a lack of communication, or just a personality conflict. Now, I have to be honest, this is a little bit of an uncomfortable subject, especially if you happen to be one of my clients or the clients of attorneys that we know or associate with. However, I do feel that it is important for all injured workers to understand how you can go about firing your attorney so that you do not feel trapped in a relationship that you no longer want or that is no longer healthy. Number 1, you just simply call your attorney and say, I no longer want you representing me. Follow up with an email or something in writing with that as well. Now, what's going to happen is you're going to request that they go ahead and send you a dismissal of attorney form. You're going to sign it, send it back to them. They're going to file it on your behalf. Then they will no longer be attorney of record on your case. There are pros and cons here. The pro is it's the easiest way to do it, the least amount of work on your part. The con is these kind of conversations can be uncomfortable a lot of times, so people usually don't like to do that. The other thing is the attorney may not be motivated to go ahead and file that on your behalf. So you might think that you fired them, but really you didn't. They're still attorney of record on your case. And so sometimes people don't like to rely on an attorney that they already had lost confidence in to do it. Number 2, you do it yourself. This is the most amount of work, but it is totally doable, and it's something that I'm going to go ahead and explain to you. Everything that you need to do it is going to be linked in the description below. First, what I want you to do is go to my link on how to access EAMS. I have a timestamp where it shows you the page that you need to see to find out all the information that you need to fill out the attorney forms and proof of service. So once you're there, you can look at the notice of dismissal of attorney and fill in all the right information. This was you, Mr. Tripp, Joe Tripp. On EAMS, it would show Joe Tripp under applicant, you would put that, and under defendant, there would show the employer, Best Jobs Incorporated. On Joe Tripp, you put that, as well as your attorney is going to be listed in the participants, so you're going to put it how it's listed on EAMS. This one is Lame Law, Los Angeles, and then you're going to put per proof of service and sign there with your address. You're also going to need a proof of service. The link is there as well to the PDF of that. And go ahead and fill in the information from EAMS. As you can see here, you're going to put in your county and your address. The date that you're mailing it out, this is the day it's actually going to be mailed through postal service. The name of the document, notice of dismissal of attorney. Now on the addresses, I have name of party 1, address party 2. This is going to be the participants on EAMS, how they're listed there, as well as their address. Do not forget to serve the board. They're the ones that actually have to file this to make it effective. On EAMS, you'll be able to see which board your case is currently filed under. There they have each board by address as well, that you'll know where to send that to. And when you actually mail off the letters, you need to make sure they're identical to what you're listing on your proof of service. And the date that you list there is the date you physically drop them in the mailbox. So once the board has received your attorney dismissal as well as your proof of service, they're going to go ahead and take your attorney off of the attorney of record in your case, and you will now be representing yourself. What this means in effect is that the defense attorney and the adjuster will both be able to talk to you directly. You'll be the one calling the shots in your case and be able to move forward with your treatment or with settlement or wherever you are in the case at the time that you sub out your attorney. So at that point, You may have questions on what to do next. There is an important resource you need to know about. That's the Information and Assistance Officer. I do have the link down as to the communication contact information to the INA officers at each of the courts. Now, these are not people that are represented by the insurance company. These are people that are paid by the state. So they do have your interest at heart because they're supposed to help people like you that are representing yourself. So you can listen to them as to what you should do if you have a question or where you should go next. Number 3, simply hire another attorney. What's going to happen is when you do your intake paperwork with the new attorney, they're going to include that dismissal form. They're going to fill it out for you. All you're going to have to do is sign. They're going to file it on your behalf, as well as a substitution of attorney where they're going to sub in as your attorney of record. Now, this skips the step where you will be representing yourself, but your new attorney will actually contact your old attorney, let them know that they are now on the case and to stop contacting you and stop working on your case. And then you will also be represented just by the new attorney. Now, some people wonder, if I hire 2 attorneys, does that mean I have to pay double the attorney fees? The answer is no, you do not. You only have the one set of attorney fees to pay, and that will be split up between the attorneys. So for example, in California, the average industry rate is 15%, 1-5. It's on contingency. So at the end, what's going to happen is that 15% will be split up by the 2 attorneys. It won't mean that you have to pay 15% to the first attorney and 15% to the second attorney. So you don't have to worry about that. Now, I feel like I need to give you a word of caution. This is something that's a little bit of inside baseball, but it's something that you really should know if you're thinking about firing your attorney. The first thing is, before you go ahead and fire your attorney, you need to make sure that you're doing it for a valid reason. Let's say you're saying, okay, I need to fire my attorney because they are horrible at communication. I ask questions and they just don't give me answers right away. Now, that might be valid if you email and call and email and call and it's been a week, 2 weeks, a month, 2 months, and they're not getting back to you. But if you're contacting them at 8 o'clock at night and they're not getting back to you by 9 o'clock the same night, that's not reasonable expectation as to communication. If that's the case and that's what you feel is not enough communication, that's not a valid reason because it's not reasonable for you to expect that from your attorney. The other way is they might say, okay, I'm going to fire my attorney because they gave me the offer of the defense, which was way too low. My case is worth way more than this. How dare they even tell me this offer? Now, that would not be a valid case because the attorney's job is to present the offer from the defense. They have to do that whether they agree with it, whether they don't, whether it's big, whether it's small. Their job is to give you the opportunity to accept it or to reject it. Just because they're giving you that offer doesn't mean they agree with it. They're just the messenger. If they didn't give you that offer, then they wouldn't be doing their job correctly. There's something you should be aware of. Not every attorney will take sub-in cases. In other words, if you've had a prior attorney, they may not look at your case at all. And the reason for that is when they're settling your case, they might actually go through almost the same amount of work or maybe the same amount of work as if they started with you, but they're going to have to split the attorney fees with somebody else. Now, that other attorney may not be reasonable in what they're asking for, so they might actually have to do more work on your case. The people that do take on cases from others are usually pretty selective in the ones that they do. If you have had one prior attorney and had a bad experience, well, that might be okay. They might take that on. But if you've had 5 to 10 attorneys in the past, well, tough love, but the problem might actually be you, not your attorney. And so what they're going to look at you and go, I think if I take on this client, they're going to have unreasonable expectation and it's going to be a very bad experience for both of us. So I'm not going to go ahead and move forward with this client. So that's something to keep in mind. The more attorneys that you've had, the more your attorney fees will be split up. The harder you're going to find it to find other attorneys to take your case. Bonus tip. If you are representing yourself and you're looking to settle and you want to know what is a good value for my case, something you need to know is that the board will actually do a DEU consultative rating. In other words, you can give your doctor report to the board and the court will rate it out and tell you how much permanent disability the doctor gave you. Sometimes people like to do this, especially if they do not trust the adjuster or the defense attorney. They think, oh, they're trying to lowball me. But this way, the information assistance officer can help you read the consultative rating, and that way you know a better idea if the offer you're giving you is a valid good offer or a good settlement offer. I hope you liked this video. If you did, press like. If you would like to see other videos about workers' compensation, things to do and mistakes to avoid, press subscribe and hit the bell for our Tuesday notifications. And please keep in mind, this is all general information. If you need information specific to your case, go ahead and give us a call or text us consult, and we'll be very happy to discuss that with you. If you have a question whether a reason to dismiss your attorney might be valid or not, go ahead and give us a call. We'll go ahead and let you know if that's something that's normal or something that might not be normal that your attorney is doing. Thank you.